All right, good morning and welcome to the Osterville Village Library. My name is Amy Wolf and I'm the programming director here at the OVL. Thank you so much for coming. Today we are honored to host the American Red Cross with a program they're presenting titled Even War Has Rules. Even War Has Rules is a dynamic discussion of international humanitarian law and how it governs armed conflict. It will address topics such as the sources of law and rules that apply to armed conflicts, and the fundamental principles of international humanitarian law that guide the development of these rules. Thank you so much.
Okay. Thanks, Amy. Thanks for your introduction. Okay, let's start. Hi, everyone. My name is Yunzi. It's my honor to be here today, and I'm really thankful for this opportunity to get us join this event and give you the lecture about international humanitarian law to you. And I will represent the American Red Cross today to introduce the international humanitarian law to you. First of all, I would like to introduce myself briefly. I'm a human rights law major. I have been a lawyer for 6 years, and I started to become a volunteer for American Red Cross since last year. So today, you can see from the title, our topic is Even War Has Rules, which is most importantly about the international humanitarian law, its origins, its principles, and some basic articles and practice about it. Let's start with the origins of the Red Cross. In 1859, the Swiss businessman Henry Dunant. In 1859, the Swiss businessman Henry Dunant arrived on the scene of the Battle of the Sorfino, Italy. In this battle, Dunant witnessed firsthand of suffering of the war. Over 13,000 men were killed or wounded, with hardly any access to medical care. What he experienced that day and the days and the weeks that followed convinced him that a corps of trained volunteers was needed to supplement military medicine and aid the wounded soldiers during armed conflict. His idea took root and inspired the founding of the International Committee of Red Cross and the Global Red Cross movement. Yeah, we just started. At most at the same time, an ocean away in the United States, another humanitarian was also witnessing the suffering caused by war. With the outbreak of the U.S. Civil War in 1861, Clara Barton realized she could not stand by when wounded soldiers and military medical personnel needed help. During the 4 years of the war, she tended to wounded soldiers, treat their wounds, wrote letters to their families, and comfort them sometimes in the last hour of their lives. When the war ended, she continued to help those in need. On a trip to Europe, she learned the Dunant's work and was quickly convinced that the United States should join the Young Red Cross movement. Returning to the U.S., she lobbied 3 different U.S. presidents and to convince them to authorize a National Red Cross Society. On May 21, 1881, at a meeting at her home, Clara Barton and others established what was then called American Association of the Red Cross, with the goal of securing U.S. ratification of the original Geneva Convention. On March 1, 1882, President Chester Arthur signed the convention. On March 1, 1882, President Chester Arthur signed the convention and the Senate ratified it 15 days later on March 16th. Henry Dunant's idea to care for sick and wounded soldiers in a battle grew into the largest humanitarian organization in the world, the International Committee of the Red Cross and Red Crescent, for short, the ICRC, remained true to its origin of providing assistance in armed conflict. The national societies, of which the American Red Cross is one, execute the Red Cross, Red Crescent mission in their respective countries. International Federation of the Red Cross and Red Crescent, its IFRC, focus on disaster response, disaster preparedness, and community health, as well as serving as a clearinghouse to coordinate the efforts of national societies. Together, the ICRC, national societies, and the IFRC formed the American Red Cross and Red Crescent movement. All of the organizations are independent bodies, none working for the other, but bonded together by a common set of unifying humanitarian principles. Although comprised of independent organizations, the International Red Cross and Red Crescent movement is united by a set of 7 fundamental principles. Together, these principles guide the movement along a common path. First, humanity. It prevents human suffering wherever it's found. Impartiality. It's relieve suffering based on need without discrimination. Neutrality is take no sides in hostilities. Universality. Red Cross and Red Crescent societies operate worldwide, and all societies are equal. Voluntary service. True to Dunant's vision of a corps of trained volunteers, the movement is grounded in voluntary participation, not for personal gain. Independence. It maintains autonomy from governments. And the last one, unity. Only one Red Cross or Red Crescent society in each country that is open to all. International Humanitarian Law is a set of rules that seek for humanitarian reasons to limit the efforts of armed conflict. It protects persons who are not or are no longer participating in hostilities and restricts the means and methods of warfare. This can be civilians, but can also be fighters who, due to being sick, wounded, or captured, are no longer able to engage in hostilities. IHL also seeks to restrict all the means and methods to limit suffering. The United States has a long history in the development of IHL, including drafting one of the very first written code to limit the efforts of the war. During U.S. Civil War, the U.S. military grew from just a few thousand soldiers and sailors in 1861 to over 1 million men in uniform by the end of the war in 1865. With such rapid growth of untrained soldiers, President Lincoln and his senior general recognized the need to have written guidance that captured both American values and the international customary law of war. In 1862, they asked the French Sliver, a Prussian immigrant and law school professor, to write the guidance. Issued in the spring of 1863, French Sliver created one of the first written documents in IHL that would eventually become known as Liber Code. The concepts written in the Liber Code had stood the test of time. Much of the language from the original Liber Code is contained in the modern Geneva Conventions and their additional protocols. In 1864, the new International Committee of the Red Cross wrote the first Geneva Convention, a set of international agreements on the rules of armed conflict. The Geneva Conventions of 1864 provided written laws for treatment of sick and wounded soldiers and sailors, established a standard, distinctive emblem to denote medical personnel and facilities, and declared the neutrality and the protection of medical personnel. Though this early agreement was originally signed and ratified by only 12 countries, it was an important step that would eventually lead to the development of the Geneva Convention of 1949. Following the original convention of 1864, other conventions were added to address specific issues, but there was no comprehensive review of the law. The shocking devastation of World War II provided these opportunities. The 4 Geneva Conventions of 1949 were written after the atrocities of World War II and contain more comprehensive laws that place limits on armed conflict. The Geneva Convention of 1949 had been signed and ratified by every country in the world. In the 1970s, many nations believed that it was again time to update IHL, and the result was the 1977 Additional Protocol 1 and 2 to the Geneva Conventions of 1949. Although the Geneva Conventions may be the best-known source of IHL, it's far from the only one. The oldest source of IHL is customary international law. Customary international law is created when a custom or practice of nations becomes so common that it reaches a point where it's considered binding law, even though it may have never been written or formally agreed upon. In fact, Francis Lieber simply wrote down much of the existing customary law on the rules of the war when creating the Lieber Code. Today, despite having Geneva Conventions and other specific treaties, nations still create and rely customary international law. The final source of IHL is judicial decisions. These decisions come from international tribunals, such as Nuremberg trials following World War II and the International Criminal Tribunal for Rwanda. So, what is an armed conflict, and why do we call it an armed conflict rather than war? War is a political declaration. Armed conflict is determined by the facts of situation. This is why you can have a war on drugs, but can't have an armed conflict on drugs. Despite many years of armed conflicts, the last declared war the US fought was the World War II. An armed conflict exists whenever there is a resort to armed force between states and protracted armed violence between governmental authorities and organized armed groups, or between such groups within a nation. When an incident moves from being a domestic police action or border dispute to being an armed conflict depends on 2 factors. The armed confrontation must reach a minimum level of intensity, and the parties involved in the conflict must show a minimum level of organization. In IHL, armed conflicts can be categorized into different classifications. The types of classifications for an armed conflict is important as it determines what rules in IHL apply, or if IHL even applies at all. An international armed conflict is when 2 or more countries engage in an armed conflict. International armed conflicts are what most people think if they hear the term war. IHL for international armed conflict is very robust and includes all 4 Geneva Conventions and Additional Protocol 1. In total, there are over 600 articles that applies to international armed conflict. Non-international armed conflict occurs when there is an armed conflict between a country and a non-state armed group, or between multiple non-state armed groups, and the fighting is contained within the borders of one country. During non-international armed conflict, only Common Article 3 and additional Protocol 2 apply. In total, there are just 29 articles that apply to non-international armed conflict. However, internal tensions or these turbulence are acts of violence that occurred within a country that do not reach to the level of an armed conflict. In this situation, domestic criminal law and law enforcement handle this issue. So it's important to know that in these situations, IHL does not apply. There are 4 fundamental principles of IHL. It's important to point out that well related to the 7 fundamental principles of the Red Cross and Red Crescent movement. They are different and are also recognized outside as fundamental principles of IHL outside the Red Cross and Red Crescent movement. As we will see over the next few minutes, the principle of military necessity grants affirmative authority, while the other 3 principles limits on the authority. One important thing to remember is that these principles are not applied in isolation. They always work together as part of an interlocking system. Military necessity is the IHL principle that justifies those measures not forbidden by international law, which is indispensable for securing complete submission of the enemy as soon as possible. Let's break down some of the key parts of this definition. Justifies those measures means it recognizes and authorizes the use of deadly force in armed conflict, which is indispensable. It's just another way to say measures that are really necessary. For securing the complete submission of enemy, recognize that complete, even unconditional surrender is a lawful goal of armed conflict. As soon as possible, recognize that winning an armed conflict as soon as possible is a valid goal. Generally, the longer a conflict lasts, the more money and lives are lost. So if this was all the definitions contained, it would mean that anything is allowed in an armed conflict. But this definition have one more part: measures not forbidden by international law. It places the restraints on military acts during the armed conflict. This part of the definition recognizes that even war has limits. The next three principles are what determines those limits. The fundamental principle of IHL requires that attacks only can be directed to military objectives. So what are military objectives? Military objectives are objects which are by their nature, use, location, and purpose makes an effective contribution to military action and whose total or partial destruction, capture, or neutralization offers a definite military advantage. Nature is a characteristic that implies the object's very existence create a military advantage. The tank in the photo demonstrates an object that exists to fight in the conflict. Location describes an object that is not normally associated with military action, but become advantageous due to its location. For example, the bridge in the photo, you can see if 2 armies were facing each other within the bridge between them, and one wants to cross the bridge to attack the other army may want to destroy it to prevent the attack. Use describes an object that is normally a civilian object, but becomes a military objective when armed force use the object for military action. The yellow school bus in the photo is a good example. So in general, the normal use of this school bus is take kids to school, but it's being used to transport soldiers, and it's become a military objective for such time as it's being used by the military. Finally, purpose. The easiest way to understand purpose is to think about its future use. While an object may not currently be used by the military, it has been designed to be used by the military in the future if needed. The interstate in the photo is a good example. The US interstate system is designed with the purpose of rapidly transferring military units around US during the time of an armed conflict. While its everyday use is to transport civilians, in times of armed conflict, it will be close to civilian traffic and used to move military units. If its purpose was to be used by the military in the future, it's considered a military objective and can be targeted. The principle of distinction. There are two parts of it. The first one is that the parties to a conflict must distinguish themselves between civilians and combatants, and between civilian objectives and military objectives. Parties to a conflict should only direct their operations and attack against combatants and military objectives. It's important to know that parties to a conflict should always assume that everyone is a civilian and every object is a civilian object, unless it's determined by its nature, location, use, or purpose to become a military objective. The second part of the principle of distinction is that the combatants have a duty to distinguish themselves from the civilian population while they are engaged in attack or military operation prior to attack. The most common way combatants do this is by wearing uniforms. In this photo, we can easily tell the combatants on the right are clearly distinguish themselves from the civilians on the left. Both parts of the principle of distinction are attempted to protect civilians and civilian objectives while recognizing armed conflicts that combatants will fight each other. Proportionality. The definition of the principle of proportionality states an attack should not be conducted if it's expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. Anticipated, that is a future-looking word. It may be human nature to look at the outcome of an attack to judge proportionality, but this is unfair. Before an attack is conducted, no one can know with certainty what the outcome will be. The harm to civilians may be greater, or the military advantage may be smaller than what was originally anticipated. It was also important to understand that the person who makes the proportionality decision is the person responsible for the attack. It could be the president, the secretary of defense. It could also be a junior private deciding whether to shoot someone with a rifle. No matter the state of the person running that analysis, the requirements to consider the principle of proportionality are the same. It's up to the person's judgment based on the information they have at that time of the decision about the expected military advantage and damage to civilian life or property. There is no mathematical formula, just the best judgment of an individual during that armed conflict. The principle of limiting unnecessary suffering attempts to limit the suffering in armed conflicts to only that which is necessary. IHL makes it clear that the right to choose methods and means of warfare is not unnecessary. It's not unlimited. To meet the legal obligations to limit unnecessary suffering, nations must conduct a review of new weapons to determine if the effects and the intended use of the weapon violate the principle of limiting unnecessary suffering. In conclusion, you can see how these principles are interwoven. The principle of military necessity permits attacks, but the principle of distinction requires that the attacks only be directed towards military objectives and combatants. Further, the damage from an attack should be proportionate to the military advantage gained, and if it's not, then the attack could be considered indiscriminate. Indiscriminate attacks would further be a violation of the principle of limiting unnecessary suffering due to the excessive damage inflicted upon the civilian population. In the media, it's unusual to hear about IHL. What people often hear about are rules of engagement, or ROE. What are ROE? ROE are the methods that a nation delegates authority under IHL to its military force. First, it's important to understand that all military operations in an armed conflict start with the full body of IHL. If a nation wants to give its military the full body of IHL, then ROE are not necessary. One way that ROE can be more restrictive than IHL is for political reasons. For example, the government may tell its soldiers that they cannot attack an enemy commander because they are in negotiations with that commander to surround his fighters, even though it may be legal under IHL to attack this enemy commander. For political reasons, the government has restricted the part of IHL for their ROE. In addition to political reasons, they may also be military or operational reasons to restrict IHL. For example, imagine that a bridge separates two opposing armed groups. As we will discuss in just a few minutes, the bridge in this situation is a valid military target under IHL because it's located between the two armies and it could create a military advantage. Despite the bridge being a lawful target, the government may tell its soldiers that they cannot destroy the bridge because they want to use it later for a counterattack. Again, even though attacking this bridge is lawful under IHL, for military reasons, the soldiers are not allowed the full authority of IHL. The intersection of law, policy, and operational concerns is where the ROE are formed. There are several categories of protected people under IHL. There are also specific rules on how certain categories of people may be treated. The rules surrounding these people are shared one common theme. The people are protected from direct attack because they are either not participating or no longer participating in hostilities. Protection of those who are not engaged in the fighting is a fundamental rule in IHL. Attacking someone who is not taking part in hostilities would violate the IHL principles of military necessity and limiting unnecessary suffering. Like the protections of people, there are also different categories of place that are protected. All civilian property should be protected and should never be deliberate object of an attack. Aside from the general protection afforded to civilian property, medical facilities, both military and civilian, cultural and historical sites, and religious facilities are entitled to enhanced protections. Their use for military purpose is also prohibited, so they cannot become the military objective. In an effort to standardize a symbol for medical personnel and facilities, the Red Cross was the first distinctive emblem authorized in original 1864 Geneva Conventions. It has no religious meaning, but it's the inverse of a Swiss flag. However, the standardization of this symbol did not last long, as some nations preferred other emblems. The first new emblem was the red crescent, which is an inverse of the Ottoman Empire flag. It was officially recognized in the late 18th centuries. Over time, more countries started to use their own emblems. To stop this practice, it was determined that only 3 symbols would exist: the red cross, red crescent, and the red crystal, a neutral emblem that is clearly not linked to any country or religion. It was approved in the 2005 Additional Protocol 3, but has seen very little use in practice. Today, the red cross, red crescent, and the red crystal are all authorized protective emblems. There are 2 uses of these emblems. The first one is protective use. When emblems are used for protective purpose, medical and religious personnel, as well as medical facilities, medical vehicles, and medical supplies, are protected against direct deliberate attack. Civilians, medical personnel, and facilities can also use protective emblems if authorized by their country to do so. People and places protected by these emblems can temporarily lose their protections if people engage in the fighting, or if the places are used by combatants to commit acts harmful to the enemy. For example, if soldiers took over a medical clinic to use it as a fighting position to fire on enemy, the medical clinic can temporarily lose its protected status and can be fired on. Of course, care must be taken to limit the efforts on the effects. Of course, care must still be taken to limit the effects on the clinic, and it regain its protected status as soon as it's no longer being used for fighting. The second use of the emblems is indicative use. The second use of the emblems is the indicative use. Indicative use is when emblems are used to identify persons, vehicles, and facilities that are part of the Red Cross and Red Crescent movement. Generally, when the emblems are used for indicative reasons, the emblems are smaller. Examples like a Red Cross t-shirt I'm wearing now, and a hat or labor pin worn by Red Cross volunteer or staff. Basically, this was a brief overview of IRL. Thank you guys. Thank you so much for coming today. And now I'm ready to take any questions.